Is the appellant ready to proceed?
Yes, Your Honor.
All right. You may.
May it please the court, Judy Madewell on behalf of Roberto Buendia. Mr. Buendia pleaded guilty to 4 counts involving conspiracy to transport and transporting non-citizens illegally in the United States, resulting in death and serious bodily injury. He was sentenced to 144 months in prison, and he appeals his sentence. The pre-sentence report calculated an advisory guideline range of 87 to 108 months. This included 4 enhancements: 2 levels for prior immigration offense, which was a prior transporting, an increase to level 18 for creating a substantial risk of death and bodily injury, a 10-level increase because one of the people transported died, and then a 2-level increase for a non-citizen being involuntarily detained through coercion or threat or a demand for payment. Buendia challenges the 2-level increase for the involuntary detention. He did not raise this issue in the district court, and so it's subject to plain error review. The facts of this case are fairly simple. Buendia was transporting 2 non-citizens, AMA and LG. I'm going to use their initials because that's what was used in the district court. LG told investigators with Homeland Security that he had made arrangements with a man named Gordo. He paid him $2,500 to bring him into the country and transport him from the border. LG and some other people were crossed over the border. At some point during the trip, it ended up being LG and AMA who arrived at the road. At the road, Mr. Buendia was there in his car. It was a Buick LaCrosse, a 4-door sedan. The 2 gentlemen got into the car. He told them to keep their heads down so they couldn't be seen, and he began driving away from the border area. Border Patrol soon started following him because they'd received information that a car meeting that description had picked up 2 non-citizens. At some point, the Border Patrol agent turned on their emergency light to pull over Mr. Buendia. At that point, Mr. Buendia started speeding to get away from law enforcement. During the ride, and it's unclear when this happened, Buendia told the 2 non-citizens that if they were encountered by law enforcement, they were to get out of the car and run. Some other time during this, LG said that LG told Buendia to stop the car, and Buendia said, "Shut up and stay quiet," and continued to drive. I say at some point because the record doesn't tell us how long this occurred, though LG indicated that this was all during a fairly short period of time. So for the 2-level increase, the guideline requires that a non-citizen be involuntarily detained through coercion, threat, or demand for payment. Neither of the parties argue that there was a demand for payment here. So the question is whether under these facts, the individual is involuntarily detained through coercion or threat. Now, the guideline doesn't define either of those terms. Excuse me, Your Honors. Doesn't define either of those terms. So we look at the common, ordinary meaning. Neither threat nor coercion are unusual terms. Lay people have a general understanding of what these mean. A threat is a statement by the speaker of an intent to harm or punish the other person. Coercion is using a threat or force to obtain compliance, to make a person do something that they don't otherwise want to do. In this case, Buendia telling LG, "Shut up and stay quiet," was not a threat. There was no communication that he intended to harm LG in any way. There wasn't a gun. there wasn't a statement, as we frequently see in cases that have applied this enhancement, there wasn't a statement of things are going to get worse for you if you don't comply. Your family will be in trouble. There was no threat to assault or anything along those lines. So that goes then to coercion. Was this involuntary detention through coercion? And there, I want to focus on the use of force to compel compliance. In this case, one could argue there was force used, in that Buendia continued to drive, continued to speed. But the force wasn't used to get LG to comply with anything. LG requested the car stop. Buendia basically said no and kept driving. There was no coercion there to get LG to not do something he might otherwise do. There's an argument, and I think...
You agree there was involuntary detention?
Yes, I do. I believe that once... The context of this is this was all an agreed interaction until someone...
There was any use of force?
Whether there was use of force to coerce LG to do something that he wouldn't otherwise do.
Well, his only option, if he wouldn't slow down and stop, was to get out of the car.
Right. So, and I agree, Your Honor. But coercion...
I agree he was driving fast enough to try to evade law enforcement.
Yes. And it would have been unsafe.
That's not a reasonable option, is it? Getting out of the car.
No, and it wouldn't have been reasonable prior to him starting to speed. I mean, just getting out of a moving vehicle is very dangerous.
So I understand the argument that the car was continuing to move because he was driving. That's how I'm going to get you here. I got to drive you. So he'd agreed to be driven, smuggled in. But once he says stop or slow down, we're just arguing now about whether or not force was involved.
So I think we're actually, I hope I'm not arguing with Your Honor, but I think we're actually talking about whether the force was used to coerce LG to do something he didn't want to do. And in both the definitions of threat and coercion, we're looking at the actor's conduct, or what the actor states. In this situation, when Buendia said no and kept driving, his intention was not to coerce LG to stay in the car. It was to get away from law enforcement. It was never about, that intention was, I'm going to keep driving because I'm trying to get away from law enforcement. It wasn't like in the situations where a house is padlocked, clearly with the intention of not allowing the people to get out. Here, even before this occurred, even before LG said, stop the car, he couldn't get out of the car. It's just at the point he said, stop the car, and Buendia said no, that's when the voluntary situation became an involuntary detention. But it may have been involuntary through force, because the car kept driving, but the guideline doesn't read through force or threat. It reads through coercion or threat. And coercion requires that additional aspect that that the actor is attempting to obtain compliance from the person. Yes, Your Honor, we are on plain air.
I'm a little trouble about why we should take this as plain error.
So there are no Fifth Circuit binding cases that deal with this fact pattern. However, the court has recognized that a straightforward application of the language of a guideline can be plain error. Additionally, so I argue that it is plain error under a straightforward application of the guidelines. And that was the U.S. v. Torres case. I have the case cite, or I can provide it to the court written after the argument. For the third prong of plain error, we have to show that it affected the defendant's substantial rights.
I think that's where your argument rises or falls, doesn't it?
Your Honor, I think that I believe that my argument doesn't fall at that point. And the reason is,
Rephrase the question. That's your best argument.
yes, Your Honor, it's my best argument. So in this case, the court did not say, regardless of the guidelines, I'm going to impose this sentence. This court has dealt with, on plain error review, cases where there's a guideline error, but the district court imposes an upward variance. And in those cases, there's something more. The court says something like, in one of the cases, and this is the Johnson case, the defendant was arguing about the drug quantity calculation. The court granted his objection and said, but the drug quantity calculation is immaterial to the sentence I'm going to impose.
Relied on the guidelines and then went upward. Is that correct?
Yes, so he granted the objection, got the lower guideline range, and then went above. Another case that this court analyzed the situation in was Zarco Beiza, which is also not in my brief, and I'll be happy to supply the court with it. In that case, the district court, it was a 1326 case, the district court had a very low guideline and said, well, on your last 1326 conviction, you got 65 months, so I'm not going to give you less than 65 months. So there was a clear indication on the record that the court, regardless of the guideline range, would not have imposed a lesser sentence. In this case, there is a reasonable probability that the district court, had it been faced with a lower guideline range, would have given a lower sentence. I'm not claiming that the court would have imposed a sentence within the lower guideline range, but the district court here anchored the sentence. I'm sorry, Your Honor.
Life imprisonment.
I'm sorry?
I said the maximum would have been 20 years and life imprisonment.
For the death, yes.
And he got 144 months?
Yes, he got 12 years.
I was just wondering what difference you expect to get from Judge Moses if you just modify the guideline deviation.
Well, Your Honor, my argument is that had the court been faced with the lower guideline originally, what the court did here is it did anchor its sentence to the guideline range. Defense counsel was asking for no more than 108 months, which was the top of the guideline range, which is 9 years. And the district court judge asked him, what do you believe a life is worth, Mr. Neary? And as he was trying to answer that, the judge asked, 9 years? What about 10 years? So the court was looking, and during this discussion, the court is pointing to all the different things that took place in the guideline calculation and the things that concerned her the most. So she went from 9 years to 10 years to 12 years. There is a reasonable probability that had the guideline range been the top near 7 years, that a 3-year enhancement there would have ended up at 10. And I ask this court to exercise its discretion to correct the error because of the substantial amount of time that Mr. Buendia is facing.
Counsel, I have a question about De Leon, and you know, I know we got the 4 prongs for plain error, and I guess I'm stuck on the plain error prong. How
Yes,
plain
Your Honor.
error it is. Tell me why De Leon isn't analogous or shouldn't apply.
So in De Leon, the defendant was harboring non-citizens in a house, his girlfriend's place, right, a stash house. And he had placed, the house was boarded up and the doors were padlocked to prevent those inside from escaping. So in this case, and when law enforcement searched the house, they found the non-citizens and firearms, as well as ledgers for the smuggling business that De Leon was running. In this case, when LG and AMA got into the car, there's no evidence they were forced into the car. This was part of the deal. When the car started driving, I'm assuming probably the locks went closed. So at this point, they already can't get out of the moving vehicle. When Buendia said as he was speeding, and LG reasonably wanted to get out of the car, when he said, no, I'm going to keep driving, there's no additional action on his part to keep LG from getting out of the car. It was still a situation that LG couldn't get out of the car unless Buendia stopped the car. And the reason he didn't stop the car was not because he wanted to make sure LG didn't get out, it's because he was being chased by law enforcement, and he was hoping to flee them.
So your argument relies solely on the intention, on his intention as to why he was speeding?
Yes, because the definitions of both terms look at the intent or the conduct of the actor.
All right.
Unless there are no further questions.
May it please the court, Matt Lathrop, the United States. I'm going to start by going to the Sentencing Commission's explanation when they created this enhancement, because I think it shows two things. One, that the purpose of this enhancement is not so much to get to the intent of the defendant, but the effect on the aliens. And the explanation of the amendment was that a 2-level enhancement is added and a minimum offense level 18 when an alien was involuntarily detained through a coercion or threat or in connection with a demand for payment after the alien was smuggled into the United States or while the alien was transported, and that this conduct might not be covered by 3A 1.3, restraint of victim, because an illegal alien, as a participant in the offense, may not be considered a victim for the purposes of that adjustment. Additionally, 3A 1.3 requires physical restraint, and involuntary detainment involved in offenses sentenced under 2L 1.1 might not actually involve physical restraint. So the purpose of the enhancement is that when the alien who's being voluntarily smuggled, who's being voluntarily potentially hidden in a house, hidden in a vehicle, suddenly is no longer voluntarily being smuggled, wants out, wants the car to stop, wants to give up to law enforcement, that then they start to look like a victim. And that's when this 2-point enhancement should apply. And I don't think, if you look at the plain and ordinary meaning of the text, there's no limitation that this just be in stash houses or times where people are actually being held where they can't leave. It can also be in a transportation. That's in the text. And so this situation where the 2 aliens are being transported, the defendant, Mr. Buendia, starts driving erratically. He's speeding. This was about a 50-mile chase. So he goes on for 50 miles until he goes right through the red light, crashes into a bystander, which then causes the Buick to go into a utility pole.
But doesn't he get sentenced for all of that conduct?
He does.
Is he already being sentenced for that?
Yes, he absolutely is being sentenced for all of that, but he's also being sentenced for the fact that one of the aliens in his vehicle said that he no longer wanted to participate in this alien smuggling venture. He wanted him to stop. He wanted him to pull over. He wanted him to give up.
These fellows want a common enterprise. We're going to come in illegally, and this guy's going to make the money by helping them. Their common objective is to get into the States and not be caught. And then carrying that out, the driver messed up. But as a result of that, now suddenly the participants in the enterprise become victims.
That's pretty much my argument, that once the participants in the enterprise say, we no longer want to be part of this enterprise. Take the example of people getting into the back of a tractor trailer. I've had cases in which aliens have made an agreement that they're going to get smuggled in a car. And they arrive at the stash house, and the next morning they're brought to the back of a tractor trailer, and they say, I don't want to do this. And they're told by the alien smuggler, you have to get in.
What's your response to counsel's argument that the intention was only to evade law enforcement?
I'm sorry, I didn't.
What is your response to opposing counsel's argument that the intention was of the speeding was only to evade law enforcement?
My response is that there's nothing in the enhancement that requires that there was intention on the part of the defendant. It simply says that the alien was involuntarily detained by coercion or threat. There's no need that there was an intent on the defendant to create that coercive situation. It's not that the coercion was something that he did for the purpose of making that alien stay. He was fully aware that the alien wanted to stop. He spoke to LG and said, sit down and shut up, when LG asked him to stop.
But there's a big difference between locking somebody in the stash house and saying, you don't leave, versus, you're in the car with me, and I want to get away. My goal is to get away from law enforcement. You understand that when you get in the car with me, that I want to get away from law enforcement, as do you, because you're being smuggled in. And he's being punished for everything he's done. I mean, for all of the smuggling, she took into account that he had done it before. All of that is taken into account. And now I want to add something else because he was in a car and the person who was a Confederate is now a victim, and he won't let them out. The only let them out is to stop the car. Then he's caught.
Well, I think it starts to apply once the alien says, I don't want to continue with this venture.
Which for this defendant is the same as saying, just turn yourself in.
But he's not.
The only way to let you out of the car is for him to stop.
Absolutely.
So what you're saying to him is, go ahead and turn yourself in.
I understand that. And that's a decision that the defendant has to make at that point. Whether he's going to continue.
Well, but LG made a decision when he got into the car with him.
That's true. But he did not make the decision that he was going to get into this high-speed pursuit. And once he's engaged in that high-speed pursuit and sees the danger of it, and again, I'll go back to the example of people in the back of a tractor trailer. If you've made the decision that you're going to get smuggled into the United States.
But he wouldn't be complaining if they had eluded the police.
If they had eluded, well, I'm not sure about that, Your Honor. I mean, what we know is they were still away from the police at the time that he said, slow down and stop. And I'm assuming he's saying that because he's frightened. He's more frightened of continuing on this drive in the way that Mr. Buendia is driving than he is frightened of being stopped by police. He's made the decision, even though he's done this whole trip in the United States, that this isn't worth it anymore. This is too dangerous of a situation. We need to stop. And he's communicated that to the defendant. And it's at that point that I think it's clear his detention in the car is now involuntary. And it's clear from the way that Mr. Buendia is driving that this is coercive. This is a frightening situation. And, as far as the coercion, other cases where we look at coercion or law enforcement questioning, if a law enforcement officer was driving this way with somebody detained in the back seat, and that's how he got a confession, that kind of driving would definitely be considered coercive. And so the driving alone in an erratic manner that causes an alien who's put a lot of money and effort into getting this far into the United States to say, no more, you need to stop, let's give up. This is a high amount of coercion. I mean, he's feeling threatened, he's afraid for his life. And obviously, tragically, the other alien in the vehicle passed away from this incident. The only case that I found in which intent was not applied is not very persuasive because it's a 2016 unpublished Ninth Circuit
What do we need to
opinion.
do with a situation where you have three guys who decide to rob the bank, and one's got to get a car, the other two go in, they get the money, they get in the car, and the alarms go off, and the police get behind them, and one of the guys says, "You're gonna get us killed. Stop this car! Stop this car!" They said, "No, we get it," and he doesn't do it. Same deal.
Well, I think there we're getting into conspiracy law, which would have different applications.
Well, they may be all kinds of.
No, I understand, but I'm also, if there was an enhancement for forcing one of your...
The argument you would be making here is that the robber, the getaway guy driver was, absconding with these two robbers.
But what I'm saying is...
They wanted to give up because they didn't want the risk of this. They didn't bother to get shot.
But my argument would be if there was an enhancement in the guidelines for when a co-conspirator decides he no longer wants to be part of the conspiracy and is involuntarily forced to stay in the getaway car, yes, those 2 points would apply, and that's what this enhancement is.
Well, to let them, it's not silly. He's not just dealing with their own self-interest. If he stops the vehicle, they're all going to get caught. And so...
Yeah, no, I completely agree with you. But what I'm saying is that here I think that's the purpose, and that's why I started with reading that Sentencing Commission's explanation of this enhancement, is that the Sentencing Commission recognized that aliens being smuggled don't quite fit as being victims. They're also not co-conspirators. And so they created this enhancement in 2006 for exactly, I think, this situation.
Well, I mean, all of that makes sense to me. It's just that you're asking us to determine that continuing to drive a car equals coercion or threat. Isn't that what you're asking?
In the circumstance where somebody has expressed that they'd like you to stop, I think it's coercion. And it's not just driving a car. It's in a way that's been described as erratic and frightening. But even if it wasn't erratic and frightening, I think if your passenger asks you to stop, is afraid of the situation or wants to, turn themselves in to law enforcement, and you're not allowing that, yeah, I do think driving a car prevents somebody from being able to get out of the situation and not having a choice, or your only choice is you throw yourself out of a moving car, is coercive. Not having a choice is a coercion. And that's the position that LG was in here. He had no choice but to continue with this particular person driving his vehicle, and he clearly did not feel comfortable with this situation, and that's why this 2-point enhancement applies for exactly the situation. When somebody who is a client, alien being smuggled, realizes this is not the venture I thought I was getting into, and I want out. I want to be done with this. And if they don't have that choice, that's when this 2 points applies. If there are no further questions, I would just ask that the court affirm and that find that the district court did not commit error and that the guideline findings and sentence should be affirmed. Thank you.
Thank you, Counsel.
Your Honors, this will be a fairly short rebuttal. unless you have questions. First of all, opposing counsel's example of the police officer driving recklessly to get a confession goes with my point, which is that the dangerous driving had to be for the intent of compelling someone to do something they didn't want to do, compelling a confession, for example. Counsel also mentioned that we should look at the fact that LG was frightened in determining whether this was coercive. And as I said, when you define coercion, it's the actor is trying to make this person do something they don't want to do. If you look at it just from the passenger being frightened, then it wouldn't have even required LG having to say stop. If the passenger gets frightened once Buendia starts speeding, under that interpretation, that could be coercion. And coercion requires that additional intent. Regarding the amendment to this guideline, the victim versus participant, I probably shouldn't say this, but I was on one of those early cases before there was this amendment, arguing that the Chapter 3 victim adjustments don't apply to the people being smuggled because they're participants in the offense. The amendment says, that I believe is the reason the amendment says 3A 1.3 likely won't apply. So it wants to be broader, and it is broader. It's much broader. It includes threat or coercion or a demand for payment, whereas 3A 1.1 is for physical restraint, tied, bound, or locked up. Unless the court has any further questions?
Well,
You're bothered.
I guess I got a question, a concern. For the government, I gotta reach the conclusion. In order to find that there was no error, I gotta conclude that that the conduct of continuing to drive erratically equals threat or coercion. But let's say I conclude that it was error for the judge to do the enhancement. Then your problem is, how plain is it? Because it needs to be plain.
Right.
What do you point to?
If I might step back here quick. Case out of this court, United States versus Torres, an opinion by Judge Smith, in which the court said,
Driving erratically and keeping somebody in the car?
no, not as good on point as I would like.
All right.
Says, any error that can be identified purely on an uncomplicated resort to the language of the guidelines is plain.
And you maintain that this is an uncomplicated?
Uncomplicated doesn't mean we don't have to think about it, but we have the tools here. I mean, both threat and coercion are commonly understood terms, and they're found in the dictionary, and the court has used that in other cases to define what coercion means.
But it does mean that it shouldn't be debatable, right? You don't agree that this is at least a debatable issue?
I would say that frequently issues are subject to various interpretations, but the overwhelming interpretation is uncomplicated based on the plain language of the statute. Unless the court has any further questions?
Any questions?
I don't.
All right. Thank you, counsel.
Thank you, Your Honors.